Let's bring in the lawyers now, because no segment about Donald Trump in 2023 is complete without the political and the legal. Danny, I'll start with you. If you had the hardest legal job in the country right now and were trying to defend Donald Trump in court, what would you be making of the things he is saying on the campaign trail, and how much harder does that make the job?
Yeah, first, there are two truths about representing Donald Trump. The first is that you do not want him talking on social media or in any context about his case. And point number two is he's going to do it anyway. At this point, if you're going to represent Donald Trump, you know that's part of the deal. You know that that's what representing him is all about. So whereas many attorneys will have a hard line of, I will never represent someone who goes out there and damages their case by talking, you just can't do that if you're going to represent Donald Trump. You know that's part of the deal, and realize that as you represent him, you may have to pivot your defenses as he says things that are damaging to his defense. And with each speech, he potentially closes off different avenues of that defense. So this is something you always have to think about when defending a client that simply won't stay off social media or won't stop talking. And frankly, it's not as uncommon as you might think. Frankly, these kinds of bad decisions that defendants make are why they need criminal defense attorneys in the first place. So Donald Trump is just the most famous, the most well-known of a long line of criminal defendants who make bad decisions. I mean, that's what criminal defense attorneys really do. We're in the business of bad decisions.
So to that end, how much does their proposal around the protective order, trying to narrow the scope of what he can and can't talk about, even matter? Is the odds are he's going to talk about what he wants to talk about. Is the point here to delay rather than try to win that argument in front of a judge?
Yes. I mean, obviously, their overall strategy is to delay, because if this gets to the inauguration, then the case goes away to the extent it's still pre-trial. But look, I may be in the minority here, but I do have some sympathy for Trump's lawyers here. They haven't seen discovery yet. And I know the government is saying, look, we're not talking about stuff that's already public. But at this point, the defense doesn't know exactly what's in discovery. And they know that if nothing else, if they don't know what's in discovery, then they need to be very careful with any protective order and limit it as much as they can. In other words, I guess narrow its scope as much as they can, knowing that their client's going to go out there and say goofy things that could land him back in court. Make no mistake about it, the defense knows that the government is watching Donald Trump like a hawk on social media or at his speeches, and if he steps out of line, they're going to be in court. So if you're defense counsel, you want to make that protective order as narrow as you can to head off as many problems as you can. And the bottom line is you're going to have problems, but that's defense counsel's role. Minimize risk. That's another big part of what we do, is just try to minimize risk.
Barbara, Danny raises 2 points that I think are worthwhile here. Number one, the idea that the Trump team doesn't know what's in discovery, it seems kind of like a little disingenuous to me. We had months of hearings of the January 6th committee. January 6th, the 2020 election, has been litigated in public for the 2.5 years since it happened. If you're the government lawyers here, if you're the prosecution team, how important are these protective order requests really, given the fact that Donald Trump already knows, at least to some degree, who are the witnesses against him, and broadly speaking, what they're probably going to say?
I think a protective order in this situation is critically important for the government. Discovery is not a license to give a defendant information to share with the public. It is shared with us of preparing his defense. There is likely grand jury testimony in here, which the law protects from disclosure. There may be recorded conversations, interviews, and if Donald Trump is able to disseminate that into the public domain, you can bet that those witnesses are going to be the target of threats and harassment. And it could even have a chilling effect on their testimony at trial. The government has an obligation to protect those witnesses. The protective order does not prevent Donald Trump from defending himself publicly. It only prevents from
Uh-oh. All right. Barbara, hold on a second. Barbara, I'm going to give our folks in the control room a chance to try to diagnose what's going on with your microphone here, and I'm going to try to ask another question to Danny here to give them an opportunity to do that. So, Danny, we reported yesterday that Bernie Kerik was in his talking to prosecutors here in the Jack Smith investigation, not in front of the grand jury, but just to prosecutors, about Rudy Giuliani's efforts to overturn the 2020 election. I'm curious how you think this is the kind of thing that might be pursued or not by the special counsel. If they pursue charges there, does it bog them down in the Trump case? I'm thinking about the superseding indictment that came out in the documents case and the idea that every time you add a defendant or every time you expand the scope of this, you slow down kind of the big case that you're really trying to push.
Yeah, I wouldn't be surprised if you never see a superseding indictment in this case, because think about it. They've already concluded that there are other co-conspirators. They're just not named in this indictment. The documents case, by example, there were 2 defendants, and then they added a new 3rd defendant. The documents case, the investigation is more recent. There you have more developing information. The DC case has been investigated for several years now, and I would think that if the government wanted to indict folks like Rudy Giuliani and they do supersede the indictment, then they won't be doing that in a couple weeks after the original indictment. Maybe I'm way off here, but I think that was a very deliberate strategy to streamline this case, as I think you were implying. I think you're right. Yeah. They're keeping other named defendants out of the case. If you add 5 additional named defendants, that's 5 additional motions to sever, motions for discovery, motions to dismiss. And Jack Smith, by naming exactly 1 defendant and other unnamed, unindicted co-conspirators, clearly is making this case as simple as he can to move it along to a speedy trial. Now, keep in mind, Jack Smith is a man of few words. And of those few words at his conference that you're seeing right there, he mentioned the words speedy trial. So in a speech that probably contained a couple hundred words, a speedy trial found its way in there. That's Jack Smith's mission. This indictment shows that. As for Bernie Kerik, very interesting character because on the one hand, he seems to be very supportive of the Trump team. But on the other hand, if you read the January 6th committee's report, this is someone who has apparently evidence that there was no there. There was no problem with the voting machines. As presumably or reportedly Giuliani's chief investigator, he apparently concluded that there wasn't anything really wrong with these machines that eventually the companies became accused of putting their thumb on the scale of the election.
Pardoned by Trump once, but that loyalty only went so far. Barbara, since I think we have you back there, I would like you to pick up on that. If we were on Jack Smith's text chain here, what's the debate like inside the special counsel team about this sort of speed versus, how wide you cast the net? Or to the point that Danny was raising earlier, are you going to haul the Trump team into court every time he says something that violates the protective order? Or do you look around and say, look, we got to pick our battles because time is of the essence here? How are they weighing those things?
Yeah, I think you have to be very strategic here. Just because you can file a motion to rein him in doesn't mean you should. You have to keep your eye on the ball and not lose sight of the forest for the trees. And so I think they're going to give him a lot of leeway about what he says. They could move to get a gag order. They haven't done that yet. If he is gagged, then what is the remedy? It's usually progressive discipline. First, a warning, then maybe a fine, and then finally revocation of release. Who's going to want to lock up somebody who is on the campaign trail for president? So it's a very difficult situation for the prosecution. So I think they're going to give him a long leash and continue to keep their eye on the ball and move this case forward. And then to Danny's point about the 6 unindicted co-conspirators, I think they wait until this trial is over. There's no reason they can't wait. The statute of limitations is 5 years for these crimes. And so I think they keep their eye on the ball, get Donald Trump convicted is the strategy. And then maybe some of those people decide to cooperate. That's great. And then even if they don't, you can indict them after this case is over and try them either together or separately.
And if I know anything about Donald Trump from my time covering him, is he's going to test that leash and see exactly what he can get away with from this DOJ team. Barbara, Danny, thank you both for your expertise on this.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.